Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi weekly community conference call every other Thursday. We'll go over the questions that have been posted, the frequently asked questions first, and if time permits, we'll have new questions. Let me rephrase that. First, we'll go over the frequently asked questions, then we'll go over the posted questions, follow-up questions, and then, if time permits, new questions. We may not have time for new questions. Today is a busy day as far as the subject matter is concerned. Okay, now, while we are talking, you can tweet to me if you like. My Twitter handle is immigrationcom, and you can also tweet to us from our homepage, immigration.com, or from the forums. Let's begin with the first frequently asked question. Am I exempt from H1 quota if my visa is not stamped? And the answer is, rightly or wrongly, USCIS has been saying that if you're outside the USA and you do not get your visa stamped, we do not consider you to be exempt from the quota. So Dhanshu Singh, the guy who posted this, says, what if we file an amendment of the existing H1? Can we claim to be quota exempt because the H1 was approved, the visa was not approved? I do not know if that is likely to work. You can try, but like I said, government could take the position because the final act for quote unquote perfecting the H1, which is getting a visa stamping done because you were outside USA, you were not applying for a change of status. Therefore, chances are they are going to make you file for fresh quota. I believe it will have to be a fresh application. How would your status be reflected? Database details, I have no clue what their databases say or look like, but I can tell you this, that chances are you are still subject to the quota. Okay. There was a follow-up question or something similar, not a follow-up, from Ramya, who says, I came to the United States in 2013. This is part of the same continuum. And applied for H-1B cap, got approved, worked for 2 months from October, later moved to H4. So in the fiscal year 2014, you did work for 2 months. So the question is, the case was withdrawn in the same fiscal year. So in 2014, 2015, Ramaya started working from October 1st, 2014, but the case was withdrawn in June. So am I subject to the quota? There has been some debate about this, that if the case is withdrawn in the same fiscal year, you will be back to being subject to the quota. That's not how I read that comment. I could be wrong because there is a lot that is not really clear. Normally, we contact USCIS and speak with them about cases like this. My own understanding from a conversation a couple of years ago is this. If you file for an H1 quota application and your H1 is not withdrawn before October 1st, even if you never join that employer, you could transfer your H1 elsewhere. You're not subject to the quota. By the reading suggested to Ramya, if the H1 is withdrawn anytime after, even after October 1st in the same fiscal year, October through September, then you're back to being subject to the quota. That's not how I understand the law to be. As long as your case is not revoked before October 1st, and October 1st comes and you have got your change of status, and let's say in August you got your change of status effective from October 1st, and another employer stepped in and wanted to transfer your H1 even before October 1st comes, I think they can. That's the way I read the law. I do not read it that if it is withdrawn in the same fiscal year, you become subject to the quota again. I personally think, Ramya, you will not be subject to the quota. But I would feel a whole lot more comfortable if somebody were to communicate with the USCIS and figure the details out. That covers my H1 quota issue. Does anybody have a follow-up question on H1 quota? Press *5. Okay, no follow-up questions. Let's go on to the next frequently asked question. This is from Phoenix IT. Does AC21 permit promotions and higher salary for same or similar job? And the answer is the law is still murky, but it's a little clearer than it used to be. It appears that normal promotions and normal pay hikes, what is normal would depend upon a case. If it's case-to-case analysis. For instance, if you get moved from Little Rock, Arkansas to San Francisco, the salary is always going to be higher. If you go from being a systems analyst to a lead systems analyst, chances are it's the same job. Little bit of a promotion or a vertical movement. If you went into a totally different job, let's say you went from being a systems analyst to, what would be a good example, network engineer, then it becomes a little bit more complicated. Does this mean that you are still covered under same or similar job AC21 criteria? I would want you to talk with a lawyer and assess your chances, because what bothers me about AC21 is it's a last ditch effort. Because if I lose my AC21, my entire green card is down the tubes. Therefore, you've got to be careful with AC21. So let's see what was posted. I joined company A in 2004 during the 4th year of my H1B. Labor was under software engineer applications. Wage was 70,000. This is back in 2005. Okay. I've been promoted several times. Natural progression, and now you're an enterprise software architect. I don't see, that looks like, after all, what is a software engineer? A guy who does the design work. What is an architect? A guy or a woman who does design work. So it looks like a natural progression, earning more than twice the original prevailing wage. And normally even that doesn't bother me, because we are talking about a 10-year delay or 11-year delay. In 11 years, if your salary has doubled in the IT industry, that's not uncommon. So the question is, will I have any problem? And the answer is, have your lawyers review the two jobs. The job of the software engineer and enterprise architect. If I were to make a guess based upon generic criteria, I would say this is not a problem. But I haven't looked at the case, I haven't compared the jobs. I wouldn't want to give you a definitive opinion, and this is an important matter. You can't take a chance with this. Have somebody review it, and somebody who knows what they're doing, and then, take your decision accordingly. Any question on this AC21 promotion? *5 on your phone. Press *5, please. I'll also check nobody has tweeted to us. I'm also checking my Twitter account from time to time. My Twitter handle is immigration.com. Okay. So we have one question. Arizona, go ahead with your question, please. Arizona.
Mr. Rajiv, are there any procedures which needs to be followed up after AC21 to maintain the AOR status?
I am not sure what you mean by procedures. You have to keep your
Do we need?
You have to keep your EAD in good shape, if possible, maintain your H1. Doesn't have to, but if you can maintain that. But AC-21, remember, does not even require any filing with the government. If you decide not to file anything, that's not illegal. But at the same time, I think the better approach is to file at least a letter with the government informing them of your AC-21 movement. Okay,
Thank you.
you're welcome. All right. Anybody else has a question? Okay. I think there was another AC-21. Let me take a quick look at it. Give me a moment, folks. I'm just looking over all our questions. I thought there was another AC-21 that was related. I guess not. Okay, let's go on to the next frequently asked question. We've got a question about N400 naturalization delay. When you have a naturalization application pending for more than a certain number of days, I forgot what that number is. I want to say it is 180 days. I could be wrong. I've forgotten exactly what the number is. You can actually sue the government because the statute itself provides for a lawsuit against delayed applications. But the key issue is, when does the delay begin? Some courts have said delays begin after background checks are cleared and interview is held. Some courts have said if the interview is held without the background checks, we will still not consider that unreasonable delay statute to run until the background check clears. So there are some twists depending upon what judicial circuit you are in. If you were, see, you just passed your interview in March, I would wait about 6 to 8 months. So April, May, June, July, August, September, October. Maybe in January of next year, if something is not taken care of, I would probably have you file a lawsuit. But before you file a lawsuit, why don't you contact your congressman's office and see if they have something they can do on your case? Normally, congressmen's offices are pretty effective in resolving delays on naturalizations. That's what I would do. So file a lawsuit maybe next year, early next year, but in the meantime, follow up through a congressman's office. Anyone has a question on this, *5, a question on naturalization delay, *5, press *5. In the meantime, I'll check my Twitter account. My Twitter account, there's nothing from you guys. Okay. My Twitter handle is immigrationcom without the dot, immigrationcom. Okay. So there's no questions. Let's move on to the next frequently asked questions. And this is a big one. I've dealt with this many times before. I'll run through it one more time. Applying for parents' green card. So if you're a US citizen and your parents come to the United States on a tourist visa and they want to apply for green card, is this a good idea? Or should they do through consular processing? And you file the I-130, they go back after they're done with their tourist visa stay and they apply for their green card through the consulate. Of course, that's also an option. Which is the better option? That depends. There are certain restrictions when you apply from within the United States. The first thing is that your parents should not have had a preconceived intention to apply for a tourist visa, applied for a green card when they entered on tourist visa. So if I enter USA, already decide in my mind, I'm going to apply for a green card, government can take an objection to that as fraudulent use of B visa. If, however, they come here, there's a two-way ticket, they haven't disposed of any property, they're still maintaining if they have a lease, or they are maintaining their house payments, it hasn't been sublet to anyone. Chances are, if they change their mind after a few months of coming here, that problem gets taken care of. If you go through but the problem is now, if they want to travel outside, they have to wait until they get until they get advanced parole, which could take a few months, 3-4 months maybe. As long as they don't mind being stranded here or being confined here in the United States for a couple of months extra, then definitely I would do rather an adjustment of status. If they want to be in India or their home country, wherever they are from, and they don't want to be stuck here, you can do consular processing, but then they can't enter USA on a tourist visa. It becomes unlikely or questionable whether entry into the United States would be permitted under tourist visa. They land at the airport, the Customs and Border Protection officer could say, okay, you have a green card going, you need to return back to India from here only. Or they could say, you have a green card pending, I'll only give you 10 days stay, and then you have to go back to your home country, whatever your home country is. So these are some of the pros and cons. You say, I'm a US citizen living in Fairfax, mother came here in June. So June, July, August, September, October, it's been quite a while. 6 months. Can she do adjustment of status? The answer is yes, as long as that was not her intention when she entered. She can go to the consulate if she wants. I've explained the pros and cons. Now, there was another question further down from somebody that is also relevant to what we are talking about. It's a continuation of the same issue from a different individual. He says or she says, I'm a naturalized US citizen looking at filing green card for my parents who are currently on the USA on B2 visa. Can we apply for premium processing for green card? No. Can I file I-130 and 45 together? Yes. How long for fingerprinting? Don't know. Approximate time 130, 485, normally within a year and a half. Advanced parole, 3-4 months. Can they legally apply for SSN based upon I-130? They have to wait for EAD. If they get employment authorization, then they can apply. Can they get insurance? No idea. If they insisted going back to India and apply only for I-130, consular processing, a year and a half. Documentation, are birth certificates of parents required? Normally, yes, but there is a list of unavailable documents. And birth certificates from certain countries before a certain date are not available. Government usually does accept that, but if you want to be doubly sure, get a letter from the municipal corporation or local government of the place where they were born saying that there is no record of their birth, which is sometimes referred to as a non-availability certificate. Then get affidavits from 2 people who were alive when your parents were born. They don't have to be adults when they were born. So if your parents are 65 years old and a 66-year-old guy wants to give an affidavit, they can, because they were alive when your parents were born. Marriage certificate, also you should get affidavits from people who attended the marriage. And affidavits can be done in USA or India depending upon where these people are located. If the people who are giving affidavits are located in USA, you can get affidavits done here, or you can get affidavits done in India. Okay, I covered this topic about applying for parents' green cards. I have one hand raised already. So don't press *5 again, your hand will go down. Anybody else has a question on this issue, press *5. Okay, I've got one hand raised, 2 hands raised. So let's go first to Washington, D.C. Your phone number is from Washington, D.C., sir or ma'am. Go ahead, please.
Yes, sir. My follow-up question to that was, you said that if I apply for I-130 right now and I do consular processing. If they plan, and it takes a year and a half, if they plan to come back, let's say next year on a business visa, and they do get in, I understand they might be stopped, but if they do get in, can they at that time apply for adjustment of status, 485, or not?
Yes, they can. And the rule is still the same. They should not have a preconceived intention to do so.
Okay.
But otherwise, yeah, there's no problem. If they have a preconceived intention, oh, we are going to visit on tourist visa, apply for adjustment of status, don't do that. That's not a good idea.
Okay. And for the affidavits and all, that was actually my question, and you answered that I can get from people who are not necessarily elder but were alive at that time and are obviously available right now. Should I proactively get those affidavits and submit along with it, or should I just submit the bare minimum documentation that's on the website needed, which is really my information, like for example, for my mother, and then they might send an RFE or they might not? Because I think it will take some time to gather the affidavits.
There are two kinds of documents submitted with a petition. There are those that are necessary and those that are optional, or they'll be required maybe later on. The ones that are necessary at the time of the filing are listed on the application itself. If the form I-485 or the I-130 says, we want birth certificates, if you don't submit them, your case can be rejected without an RFE. So look at the instructions. If the instructions say this is required, submit it. If the instructions say it's not required, you can submit without those documents and submit them later.
Okay, got it. Thank you.
You're welcome. Okay, let's go on to the second. Virginia, go ahead, please. You have a follow-up on this issue?
Yes, Rajiv, I have a question about this, where you said that if somebody doesn't have a preconceived notion of applying the green card in their mind while they were applying for the tourist visa, they can do the adjustment of status while they are living in US. So this is a vague term, like not a preconceived thing. You said that if they have not sold the house or if they have waited for some time, then yes, their case seems genuine. But I mean, like in this case, like she realized that her birth certificate was not there, and she found out that her birth date, which she has been using from so long, was wrong. And based on her birth certificate, she got it changed on all her documents, and because of some other reason, because of the property dispute going on in India, and she got those things changed on her passport before applying for the tourist visa. Will that be considered the preconceived notion, or, I mean, such a vague term, I didn't understand that.
Sure.
What do you mean by preconceived notion?
Let me explain that to you. I think your observation that this is a vague term, what is preconceived intention, is correct. There is a spectrum of bright white and dark black. Some things are obvious. If somebody enters the United States today on a tourist visa and tomorrow applies for an adjustment of status, it's a very clear indication that they had a preconceived intention, right?
Yes.
Right. So because intention is a state of mind, it can only be inferred through circumstantial evidence. So circumstantial evidence pieces that are most commonly examined are, if you apply within 30 days of entry, it is evidence of a preconceived intention. 60 days, it can still be questionable. After 60 days, maybe not questionable. After 3 months, that idea that you applied too quickly is gone altogether. Then we look at, did you have a two-way ticket? So if you only brought somebody in on a one-way ticket, it looks like they want to stay. Another example is if they landed up with all the papers, like in your case, your mother came in with a birth certificate, does that mean that she has a preconceived intention? Remember, applying for an I-130 is not a problem. But applying for a 485 can become questionable. Now, I'll give you this also. I know plenty of people who've never had a problem. But we also see those cases where there were problems. Therefore, we always want people to be prepared for it. And normally, if you apply after 3-4 months of their entry, they don't create that big an issue unless there are other things that point to it being a preconceived scheme. Okay? Ma'am?
Okay, and
Yeah. Go ahead.
and you also mentioned that there is no problem if she is living here on a tourist visa and applying her green card to be processed in India, like from the US consulate.
Sure.
And that is also okay if she stays for 3 months on a tourist visa, goes back and do the remaining processing from India and come back after a year.
Sure, that's no problem at all. That's no problem at all. Because remember, if let's say she entered United States yesterday and today you applied for an I-130, I don't see anything inappropriate about it. Because you're not asking for a change over to green card. You're asking for the right to green card through consular processing. So in that case, mom and dad are secure. I don't see any problem there. So I-130 consular processing can be filed at any time. Okay?
Okay, thank you.
You're welcome. Good luck. I think I have another hand, or maybe the same one. Washington, D.C. Go ahead, please. Washington, D.C.
Just a follow-up question. I was thinking about this. You said if I-130 and 485 are filed together, the time frame for both of them to get approved is approximately a year, even if it's filed both in the U.S.?
Yes, typically. Now, I'm just giving you a rough guess. USCIS has made public their intention that they consider 6 months to be the normal processing time default for all cases. So if we do 6 months plus 6 months for I-130, 485, that's the default time they shoot for. Sometimes it's as quick as 4 months. Sometimes it can be as much as a year and a half. But it looks to me like about a year is good planning perspective.
About a year. Okay, so I was just anticipating the case where, because fingerprinting may come after 1 or 2 months, and then immunization they may say go for it after 1 or 2 months. So by that time, if advance parole is not received and they go back, would that be considered abandonment of the application, or would that be a problem?
It's an abandonment of the 485. If you travel without the advance parole, it's an abandonment of the 485. Okay.
Okay. In that case, and I'm probably now thinking I won't do that, but I'm just thinking if we did do it and they did travel, then is there a process to say take the 485 back and opt for consular processing instead?
Yes, that would add another 6 to 8 months to the process. There's a form called Form I-864, which you will file after the I-130 is approved. Right now, they don't have anything more streamlined than that, but that is the process these days to convert a adjustment case to a consular processing case.
I see. And there's no link in the time process for advance parole and fingerprinting and all that. Those are independent things, right?
They are independent things. Biometrics proceed separately, and the time frame for advanced parole EAD proceeds separately.
Okay. I was just thinking if they get 3-4 months advance parole, then even the other things, if they have to go and come back, that's feasible. But if we need to travel before that, then it's probably advisable not to do it at this point.
See, I would prepare them for a longer time, but I would be surprised if it doesn't come within 4 to 6 months. Closer to 3 months actually, because EADs are technically supposed to be processed within 90 days.
Within 90 days. Okay.
Okay.
Thank you again.
You're welcome. Good luck. Okay, so let's go on to the next frequently asked question, if there is one. And then, here's one. Continuing work outside USA despite approval of L1A. Folks, I hate to disappoint. I know there's a lot of people who just joined in. I may not have time for new questions today. You can stay on and see if we have time and if I have the stamina. But we have a lot of questions already posted. Some of them do require a very lengthy discussion, like the L1A. So the question is, I'm working outside USA. My L1A is approved. Can I continue working for a branch of that company, or am I required to come in the United States within a certain number of weeks or months? The answer is you can continue working outside as long as you please. L1A is a very interesting, L1s are interesting visas in a couple of regards. H1s are like that too, but some small differences. L1A, your salary can be paid outside US. You don't have to be paid inside US. Number two, you have the right but not the obligation to come to the United States. So if you come only 3 days in 3 years, that's fine. If you come 3 months in 3 years, that's fine. Sometimes for international CEOs, because consulates are so picky about B1, B2s and so finicky, we sometimes just do an L1 so that their meetings are not going to be interrupted. And they only come maybe 5 days a year to attend meetings or attend intra-company conferences. So L1 does not require you to be in the United States even after approval. There is no problem. I think the question here is a little bit different. Maybe I misunderstood. Let me revisit this question. You said I'm currently on L1A with a foreign subsidiary of a US company. That doesn't make sense. To transfer me to parent company. So I guess both these companies are in the United States. So once the L1A amendment is approved, can I still work with the original sponsoring employer? I think that's what you're asking. And I'm not sure what the answer to that question is. I suspect the amendment will overrule your right to work at the original petitioner. But normally, when you file for an amendment, we can actually cover both companies. And I don't remember the law on this issue. I'll have to check the law. But there may be something in the regulations that says if you are working for the same group of companies, even an amendment is not necessary unless there is a huge change in the job description. You can double check that law, but I think something like that also is an exception. Now, there is a hand up from an individual from Illinois. If it's related to this question, you can leave it up. If it's a new question, press *5 again and put your hand down, please. We'll not do new questions until I'm done with the posted questions. Okay, so anybody who has a related question about L1A, press *5. Your hand, Illinois, is up already. You can leave it up. *5. Okay, let's take Illinois first. Yes, Illinois, go ahead, please. We can hear you.
Yeah, Raju. Actually, my situation is like I'm working for for example, company A US has a subsidiary in company A India, and company A India filed my L1A, and they had they had created another subsidiary company A India US, and they filed my L1A, and I came here in US, and I have been here for some time. Now, to green card processing, company A India had policy of not processing green cards, so they want me to move to company A US, the parent company, so which is parent company to all the three. So now when they are filing for amendment to move me from company A India US to company A US, so in that case, once amendment, they have already filed the amendment, and once it is approved, so my query is can I still work with the previous company, which is company A India US, or I have to move to company A US immediately?
Okay, let me interrupt you. I understood your situation. You were sponsored by an Indian company to work in the United States on L1A. That Indian company now has another parent who owns all their subsidiaries. Question is, if you amend to work for the parent, can you still continue to work for a subsidiary? Is that correct?
Yeah, that's
Okay.
correct.
Well, first of all, the way I see this situation, why do you need to do an L1A amendment? You can directly file an EB1C based green card for your parent without doing an L1A amendment, because green card job is a job in the future. And this is a same group of companies. I don't even see a need for an L1A amendment.
Okay.
Okay?
Yep.
Good luck.
Yeah, thank you.
You're welcome. Next question, next frequently asked question. Let's see if there's any. I did tell, somebody had posted a question about political asylum. And I did mention that we don't do political asylum, so I have zero knowledge of how that process works. Our work is focused intensely on legal immigration, and on top of that, well, not that political asylums are illegal, but employment-based immigration, family-based immigration. But bulk of my own work is employment-based and business-based immigration. So I have no knowledge of political asylums. Last time I did one was in 1993 as a favor to a friend. Okay, so now we will start with questions that were posted that are not frequently asked questions. Ramaya's question I already answered. Now look at Krish 176. I have a pending 485 thinking to consider change of employment with company B. Employer A will not revoke my I-140. Job title with current employer is programmer analyst. The other job is lead systems analyst. Actual duties are same. Keywords, technical terms are 50 to 60% match. Look, in my view, if you are a database administrator and you go from being a MySQL or MS SQL database to Oracle, and you're still a database administrator, the fact that the underlying technology changed doesn't bother me, because they're relational databases. A lot of what they do is very similar. So I don't think that merely change in the technologies matters that much. This is my opinion. I have never seen anything from the government that either agrees with me or disagrees with me. But I would bet money that I would be able to win that argument. That technology is irrelevant, nature of the job is relevant. So if I'm hammering a nail, whether I use a huge hammer or a small hammer, or I use the back of a lock, how does it matter? Hammering nail is my job. That's what I'm doing. So that's the way I see it. But I think, look, Krish, this is such an important benefit, AC21. You should talk with a lawyer, have them review the two jobs side by side, look at the salaries, look at the job descriptions, job titles, job requirements, only then come to a decision. None of these are error-free or hassle-free. Let me double check my tweets, 21 notifications while we were talking. Okay, nothing from you guys, just checking my Twitter from time to time. Okay, so therefore, I would want you to sit with your lawyers and go over it line by line. Now, new company will give a letter as per their standard format, not customized to match the keywords. I don't think you should ever customize unless it is true. And if it is true, then even though it is not customized, but the concepts are the same. So if somebody calls your position a programmer analyst and they have you designing and developing and testing, another one calls you senior systems lead and they have you developing and quality assurance, not testing, the same principle, same idea. Okay. So are you taking a risk? That's really, it's a fact-based issue. You have to talk with a lawyer. Salary in the labor was 70K, now it is 125. But this was back in 2009. So in 7 years, 78% does not bother me. But again, it should be reviewed by your lawyers. If the old employer gets ability to pay RFE, will it be applied to new employer? No. But here is a risk that everybody needs to be aware of. In AC21, you have moved over to a new employer, and 6 months after you moved, or 8 months, or 10 months, or a year later, the old employer gets a notice of intent to revoke saying either the I-140 was approved in error or the I-140 was approved based upon fraudulent misrepresentation. You will lose everything if that is denied, that is revoked, because revocation means that I-140 doesn't exist. However, ability to pay wages is limited to the old employer, not to the new employer. If you have ported over using AC21 beginning September 9th, 2016, from September 9th, 2016 backwards, the ability to pay wages of the old employer is relevant. Past that point, you've already moved out, it's not relevant. And under AC21, the new employer does not have to prove their ability to pay wages. But if the old I-140 gets revoked, if the employer revokes the I-140 after you have ported over, there's no problem. Once 180 days have passed, they revoke it, no problem. But if government revokes it on two grounds, either misrepresentation or two, approved in error, then you've got a problem. You've got nothing. Okay, so I think I've covered everything that you've asked. If you're on the phone, Krish, press *5. Anybody has a follow-up question on this, press *5. No new questions, follow-ups only. *5, folks. Okay, Deepa is has earned an MBA in technology from the United States in 2009. Employer went out of business after the H-1B. I worked on OPT of Trivalley University. I don't know how many of you remember that. But you know, Deepa, if you were not actively involved in any fraud in the Trivalley University, and like you weren't employed with them, you were just a student there, you shouldn't have a problem. And the fact that you got an H-1B is a strong indication that Trivalley University is no longer going to be a problem. Can I start the green card through my employer? Why not? How much is the cost involved? If you come to the end of the discussion here online, I have given you a link. If you go to immigration.com, on the very top, we have our fees, very top. You can click on that and see our fees. All of this is everything that you asked for in terms of our fees are published. They are on the web. You can go to the fees page right on top. On immigration.com, the very top banner has a link to our fees. Okay, then what else did you have? Timeline of each stage completion. That's very difficult for me to give you at this point of time. If you folks are interested and you want to talk with us, we'll give you an estimate based upon the then current situation whenever you get started. But you remember your biggest problem, if you are India born and your husband is India born, your green card is going to take a long time, not because of the government processing times, but because of visa movement times. Is Trivalley going to be a problem? I'm not that concerned, Deepa. If you are on the phone, press *5 if you have a follow-up question. *5, Deepaji. Okay. Sam1236 says, currently I'm in India, my petition was approved, that is H-1B. For 1 year, on December 15th, good till December 7th, or till 7th December 1916, so another 3-4 months. And H-1 visa was stamped on 1st March, but never used. It's also expiring 7th December. Now I want to travel on a different project in the same company. So I need to apply for amendment. Because my H1 is valid only for 90 days, should my company also apply for H1 extension? I think so. If you want to be here for a longer period of time, you should. And I don't like people traveling. Hang on, I've got a bunch of notifications on my Twitter. Nothing from you guys. Okay. So I don't like people traveling if they've been approved for project X on an H1B and they want to join project Y. I would wait for the amendment and only then come. Do you need visa restamping? I don't think so. If you ask the consulate, they will tell you you need restamping. I have had an argument about this with them, and I showed them data from their own standard operating procedures that shows that a visa should not be required. If you are adventurous, you can go for visa stamping. In fact, where visa is not required were cases where somebody was already working here. So you might have to go for visa stamping again. I changed my mind. Your situation is a little different. So yes, I would get the amendment, get the visa stamping, and only then travel. Okay. *5 if you're on the phone and have follow-up questions. *5. So now Mr. Agarwal, Gyanendra Agarwal, has received his green card. Can he leave after 6 months? And the answer is yes. Especially where the company is going out of business or they have lost a big contract. I think it's perfectly safe. I don't think you should have any problem. Your green card cannot be revoked for leaving the company earlier. If you leave within 6 months of the green card approval, see if there's a good reason. The most important point is, and we have a lot of frequently asked questions on this. If you go to our frequently asked questions, they are right on again. If you go to immigration.com and look at the top bar, there's a link to our frequently asked questions. So just go there and read through how soon can I leave. I think I also have some blog entries on that, and also link to my blog is available on the top panel or the top ribbon of immigration.com. Okay, so if you had a good reason, you could change even a few weeks after getting a green card. Most important point is the point at which green card is approved. If you had the intention to stay with the employer at that point when the green card was approved, if 2 days later your intention changed for good reason, whether the employer changed the working circumstances or you got a much better job offer somewhere, I think you're okay to leave. It should not be something that you have planned, and it should be something that developed later on. *5 if you have a question on this. *5. Okay. California, go ahead, please. California.
Yes, Mr. Rajiv, I have a same question. I got my green card in June this year, and now my employer is like kind of like I'm assuming that he doesn't like me, that I can continue in the same job, but I just have a fear that he will not revoke my green card, and I wanted to go in the same profession, in the same field, on another job. So can he do something if I move from A job to B job, means in the same profession?
Employer cannot revoke your green card. There is no such process.
Yeah, but what I have seen that my family's means green card means I know that it was like my green card came very sooner, and we all applied in same time. But I think their green card is now taking a longer time than usual, and that's what I'm thinking. problem for me. So
I
and
don't
so
I don't think they can create a problem. That's my opinion. Okay?
okay, yeah. So I can change the job in the same profession if I.
I believe you can. Yes, sir.
Thank you very much, sir.
You're welcome. Good luck. Jerica, that name is familiar actually. I was picked in the H-1B lottery this year, got an RFE, still collecting the documents to respond. Deadline is 11th October. Another offer. So can I do a transfer while this one is still pending? I don't think you can. Once the H-1B is approved, I think then you can. I have a very interesting situation, sort of like yours. The only difference is company applied for H1, got selected in the lottery, but while the case was pending, that project ended. They have a new project going, and the OPT is still good till February or March. So I felt that we could file an amendment under those circumstances. But if it's a totally different employer, I'm not sure you can. And you can premium your application anytime, before you respond to the RFE, later, it doesn't matter. Once the H-1B gets approved, there are two schools of thought. One school of thought says you must be working for that company on October 1st. I don't see any reason for that. Frankly, that is not the law as I see it. But second school of thought, like I said, is mine, which is as long as your case is not revoked before October 1st, you should be able to transfer even if you don't join that employer. That's my take on this. Star 5 if you have a follow-up question. Star 5. Okay. I'm a permanent resident, port of entry date category IR1. Applied for a re-entry permit. So basically, you've got your re-entry permit, but you've returned and you want to surrender the re-entry permit. There is really no need for you to surrender a re-entry permit as long as you have proof that you are in the United States. You can call USCIS customer service and see if there is a procedure for it. I don't believe there is. You have never stayed outside the US, say, for more than 6 months. Does the 3-year residency period begin on the date of first entry? Yes, that's when the 3-year period begins. When you first entered the United States as spouse of a US citizen. That's when it begins. Star 5 if you have a question, star 5. Any question on this, press star 5. Okay. Shane wants to know, I joined company B in 2013. You started with B, where is A? Okay. Before that, I had worked in the US with L1B for 3 years in company A. Okay, got it. Company B filed my labor cert and I-140 under consular, got approved. Priority date is October 2013. B will not give me my I-140, but they won't revoke it. I quit B, traveled on H4, applied H1B. So can I file a Freedom of Information Act? Sure, it doesn't cost you anything. And chances are you might be able to get both I-140 and H1B approval copies. Government is inconsistent in this. Sometimes they give you some documents, sometimes some other documents, but it's definitely worth a shot. Nothing to lose. Star 5 if you have follow-up questions. Any follow-up questions on this? Next question is, how do we prove the place of birth, Nepal, when somebody had an Indian passport, his wife, his fiancée actually. She's a Nepal-born Indian citizen, no proof of birth. I think you had posted this earlier also, a couple of months ago, and I told you one easy way to do it is get a declaratory judgment from an Indian court saying that she's Nepal-born, or maybe even a declaratory judgment from a Nepalese court that says she's Nepal born. Based upon that, get a birth certificate made in Nepal. There are several ways you could do that. Okay, just having an Indian passport with country of birth as Nepal may not be enough. But you can try that too. I personally feel going through the court system would be more secure. So, what are the possible risks to me if USCIS doesn't accept these documents? Denial of green card application of my fiance only. Well, if are you employment based? What are you trying to do? Yeah, EB2. So they can deny your cross chargeability and say that you're not entitled to filing 485. Her case, they will deny her 485, and of course you can always refile with the right documents. But claiming documents are fraudulent, unless they are fraudulent, I wouldn't worry about it. I don't see any other worst case scenario. *5 if you have a follow-up question on this. *5. Okay, we've discussed, oh, there you are. Go ahead, you're probably on a voice over IP. Go ahead, I don't know. Yeah, go ahead.
So, Rajiv, my question is, you mentioned that a declaratory judgment from a court is a better way of doing it.
Yeah, I think it might be, in my view, as I'm thinking about it. What if you could go to a court in Nepal and get them to issue a judgment that she's indeed born in Nepal, and based upon that, get a birth certificate from Nepal, get a copy of that judgment, get a copy of that birth certificate, and submit it. Of course, if you can also get the Indian passport amended to show the place of birth as Nepal, that should take care of it. That, I think, is the more secure way to do it.
No, as I mentioned in the question that I am trying to get the Indian passport made with country of birth mentioned as Nepal.
Hang on. I think that by itself is not sufficient.
Oh, you're saying that? No, that together with a certificate of no record.
Still not sufficient. I think, because, look, here's my problem. She's holding herself out to be an Indian citizen. And so far, any documents that she would have filed with the government would have her place of birth as India, probably. Right? Any immigration documents so far?
No immigration document has been filed.
In that case, it might work, because what you are doing is you are correcting the Indian passport to reflect her place of birth as Nepal. Then you are going to Nepal and getting a certificate of non-availability and 2 affidavits from people who know personally when she was born. It might work. But if there is any document that has been sent to the government showing India as her place of birth, you will have to go through the court system.
Okay. As far as I know, so far no such government document has been sent or made that mentions her place of birth as India. Because it hasn't been recorded in any government document so far. That's my understanding, but I'll confirm once again. But if that is the case, then your recommendation is the declaratory judgment from a court. Does that declaratory judgment need to come from a court in India or from a court in Nepal?
I was going to say India, but I think Nepal is better.
So I'm not familiar about. So wouldn't the declaratory judgment from the court itself require some documentary evidence before?
I don't practice law in Nepal. I can only tell you what I think would work. Will it be functional, can be made to happen, that's between you and a lawyer from Nepal. I've got to go on. I've got a bunch of questions still left. Okay. Good luck. Getting back to Abhishek Verma, we already answered the questions about naturalization. Abhishek Verma says, I was in a job with a banking firm in New York. They did not successfully do my green card. Had to leave USA in 2013. 6 years were over. I can come back on a new H1 365 days. Make it 366. I was back in USA on, see, you have to be physically outside the USA to reset your H1B period. If you are here on a student visa, that doesn't count. You have to be outside USA. So people who told you you're here on F1, that's okay. No, that's not okay. And you can always travel with two passports. Old passport has the visa, new passport has the validity. That, in fact, it's there on the CBP website also. If you go to the Customs and Border Protection website, it's one of their frequently asked questions. They are okay with you traveling with stamp on the old passport and validity on the new passport. Any follow-up questions on this, press *5. Jane US 99 says, can we file H1B extension before 6 months of expiration? The answer is no. Next question. This is KTL, moved from company A to a small privately owned company B as an operations manager. H1B just got stuck in the RFE and finally got denied. Then did not file an appeal, started afresh. See, I have a problem with your situation because I don't know if your I-94 expired more than 180 days ago. You might have a problem of unlawful presence. Remember, if your I-94 expires and there's nothing pending in between applications, you could be accruing unlawful presence. That's something you should discuss with your lawyers and make sure you're not subject to 3-year or 10-year bar from entering the United States or from getting green card or H1 again. So once you get a stamp and you come back and start working for a company, there is no cooling off period before you can apply for a transfer over. Those were the two questions you had posted basically. *5 if you have a follow-up question. *5. Okay. So Vijay wants to know, I guess this is the last posted question. I'm a resident of India working for a US-based multinational for the past 5 years. Intra-company transfer was offered, but my mother is taking treatment for stage 4 cancer. I'm sorry, man. As treatment options are limited, insurance coverage, I wouldn't know anything about insurance coverage. Really not my field. You have 3 questions, 2 questions on insurance coverage, which I don't know. Third, visa issuance is a problem? No. Cancer is not a communicable disease. They don't usually create a problem with that. And father and sister want to travel with her. They are subject to the same rules, Vijayji, as anybody who's applying for a tourist visa is. Will they get it? Will they not get it? I don't know. I can't predict that. That was the last question. If you're on the phone, press *5. *5. Okay. Most of the people have logged out. There is only a few people left. So I can answer any new questions you have. Press *5 for any questions. *5 for any questions, new, old, follow-ups, doesn't matter. Okay, I guess we are done. Well, folks, as always, it is a great pleasure, and I will see you again in 2 weeks. Thank you for being here. Bye now. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.